Alright, hello and welcome to this criminal law capsule. And in this capsule, I am going to provide a very basic overview of how sentencing is conducted in Canada. I have another capsule you may want to look at that looks at sentencing tools, so I'm not going to talk about the types of punishments that are available. Instead, I'm just going to focus very generally on the main constraints that are imposed on a trial judge when somebody is found guilty and it's time to go to sentencing. So how does it take place? Let's jump right into it. So traditionally, judges had a great deal of discretion in imposing a sentence. And what I mean by that is when you talk about something like discretion, what it means is there's a lot of room in that the statute itself does not provide an incredible amount of guidance about how a judge should proceed. And this was the type of provision that, virtually was the only type of provision in the code, except for a few mandatory penalties we'll come to. They all look like this. So essentially what you said was that the person's guilty of the offense and they are liable. And a libel essentially means up to, 14 years where the subject matter exceeds $5,000. So this is a qualifier. It has to be, a form of relatively serious fraud. And that is the maximum, 14. However, it doesn't tell you very much about what the judge should impose. It's essentially anywhere from 0 years, and theoretically that includes all the sentencing tools that I talk about in the other capsule, including probation or a fine, right up to 14 years. Very little in the way of what it should be. Now, fraud is a good example because fraud shows you the different types of penalties that are available. So keep in mind that as I talk about in another capsule on classification of offenses, fraud can be committed, it can be divided into different types of severity. Now keep in mind, these are not sentencing provisions per se, these are actually different offenses. If it's called fraud over $5,000, you're into potentially this category. And if it's under $5,000, you're under this category, which is an indictable offense up to 2 years or an offense punishable on summary conviction. So this is a hybrid offense. Again, if you haven't listened to the capsule on classification of offenses, it's a good thing to do. But these are, again, don't really tell you much about how the offense should take place, or sorry, what the punishment should be for that offense. It's just up to 2 years, or up to summary conviction, which is a 6-month maximum where there is no penalty specifically listed. Now, over, say, the last 20, 30 years, Parliament has not been satisfied with general discretion for judges because general discretion for judges, as you will see, is just that. It gives judges a lot of leeway to make decisions, and sometimes that means they'll make decisions that are not politically popular. So the Parliament has been trying to push back by putting in mandatory minimum sentences. The most famous of those, of course, is for murder, which murder has a mandatory minimum penalty of life imprisonment, and depending upon the type of murder it is, there is also an additional period of parole and eligibility, which means that no matter what the judge wants to do, the judge is bound by the mandatory minimum, and that is true here as well. Section 381.1 makes it clear that if the subject matter of the offense is over $1 million, the judge has no choice. You are starting from 2 years and you can only go up from there. So the judge, let me be clear, the judge still has a fair bit of sentencing discretion because the judge can punish anywhere from 2 to life and can add on a fine and can add on all kinds of other things, but the mandatory minimum caps the bottom end of the range. The judge cannot go lower than this 2-year penalty. Now let me just say, while it's beyond the scope of this podcast to deal with this in depth, it's a good thing to keep in mind that mandatory minimum penalties are all subject to oversight by the Charter of Rights and Freedoms, and in particular Section 12 of the Charter, which subjects the person not to be punished by cruel and unusual punishment. And let's just say that many of these mandatory minimums have been subject to test under the Section 12 of the Charter, and many of them have been struck down. This one has not, but many have. And the reason for that is that a mandatory minimum caps the judge's ability to look at individual circumstances. And as you're going to see as we go in to looking at the principles more generally, every case really is different, and usually judges have a lot of leeway because they need to be able to deal with the different circumstances of every case. Mandatory minimums take away that flexibility, and as a result they do get tested under Section 12 of the Charter, and where the court finds that they are inconsistent with that section, they will be struck down, as many have, though some have been upheld. Now, fraud is another great example of another more recent development, which I like to refer to as specific aggravating circumstances for an offense. And I should stress that most offenses do not have this kind of guidance, but if we're looking at, where does the judge start in deciding what penalty a person should face when they just have a maximum of 14 and no minimum if it's under $1 million, right? Where should the judge start? Well, you start with Section 380 sub 1. Whenever there is a specific limitation on the discretion, and Section 380 sub 1 lists a number of what are called aggravating circumstances. So, magnitude and duration of the fraud, the longer the fraud was, did it affect financial markets, did it have a significant impact, were there a lot of victims, and it goes on and on. Let me just say for the record that most of these circumstances would probably be considered under the judge's general discretion anyway, but listing what they are, I think, is fairly helpful. It provides judges with clearer guidance, and in a certain extent, it constrains their discretion by guiding them to a particular type of sentence, depending upon whether or not any of these circumstances were present. But let us say that we are looking at one of the many crimes in the code, most of them, frankly, that have no specific guidance. So what I mean by that is there is no mandatory minimum, and there are no specific aggravating or mitigating circumstances listed in relation to the offense. Where do we go from there? Well, without question, the most fundamental principle of sentencing, and that's what it's called, is that the sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. So let me be clear, these are the main controlling factors. 1, gravity of the offense. 2, the degree of responsibility. The Supreme Court has held that they are not exclusive, so I'm going to get into and explain you what they are, but I'm going to tell you that, you will find other factors that can affect a person's sentence that have nothing to do with the gravity of the offense, which is how serious was the harm caused by the offending, or the degree of responsibility of the offender. Meaning, as I'll get into, all the things that cause the person to do it, whether they intended to cause the harm, etc. There are other factors that are relevant, and one worth keeping in mind is something called collateral consequences. The court has held that even though these collateral consequences do not comply, in a sense, with Section 718, because they have nothing to do with gravity and degree of responsibility, a court is permitted to adjust the sentence, marginally, to allow for collateral consequences. And collateral consequences include the fact that, well, you lost your job because you committed the offense. Or if you are convicted in a particular way, you will be deported. These are what are called collateral consequences, and while they cannot be the primary responsibility, because the sentence has to be proportionate, the judge is allowed to consider these factors even though they don't really comply with either aspect of Section 718.1. So, long story short, these are the main factors. Other factors are also relevant in assessing what sentence should be handed down. So let's quickly get back to these factors. Number 1, how serious was the harm caused by the offending? This factor considers everything you'd imagine. In a case of violence, there will be a variance, to keep it within fraud, for example. So what we know is fraud over $5,000. Okay, and we know if it goes over $1 million, then it's obviously a bigger penalty. But between $5,000 and $1 million is a lot of range. Was it $100,000? Was it $8,000? Well, that's number 1. How serious was the harm? Who were the victims? There is a difference between a fraud that scams old people and a fraud that, I'm not saying it should be countenanced, but I'm just saying there's still a difference when we're measuring how serious the fraud is, because that's what we're looking for, how serious, between a fraud where, for example, somebody scams pennies off every transaction from a large corporation. Not good, but at the end of the day, a smaller drop in the ocean than robbing a bunch of old people from every dollar that they have. So again, the idea with the gravity of the offense is to recognize that not all crimes are equal when it comes to punishing for them. And I'm going to tell you as we go forward that it's a cardinal principle of Canadian law, and a really important one, that when we're going to decide, is the person guilty, we're not really looking at the severity of the offending. In other words, the person who scams the corporation of $8,000 and the guy who causes the old people to be scammed for $100,000 are both guilty of the same offense: fraud. Fraud over $5,000. That's it. However, they're not the same when it comes to punishing them. So the most important principle of sentencing is we vary the sentence depending on the gravity of the offense. And we also vary it with respect to the degree of responsibility of the offender, a much more complex inquiry because it looks at so many different things. Generally speaking, with degree of responsibility, one thing we are looking at is intention. And what I mean by that is you are going to learn about intention later on in this course, and one thing you'll learn about intention is there are different levels of intention. In other words, you are going to learn that manslaughter, for example, is an offense that is caused where somebody objectively causes bodily harm. So even if they didn't mean to, the fact that objectively it was reasonable to foresee that bodily harm would come from their actions, that's enough to consider manslaughter if somebody dies. But as you will also see, manslaughter also includes somebody who subjectively causes bodily harm that ends up causing somebody to die. Those are both manslaughter, and I can tell you they're different types of manslaughter. When it comes to punishment, the person who intends not the result that happens, because that would be death, which would make it murder, but somebody who intends to really harm somebody, and somebody who doesn't, but does it sort of not accidentally, but yeah, unintentionally, those are different types of things. Motivation will be considered in this degree of responsibility. Was it pure greed, or were you trying to save your family from starvation? Were you acting under some sort of mistake? As you will learn, mistake of law in particular is not an excuse, but it certainly is a mitigating factor on sentencing. And also, when you're dealing with what's called the actus reus, what was the accused's role? When we get further into this course, you're going to look at something called party liability. And party liability means that if two people do something together, they're both guilty of the crime. So think about it this way. If A and B go together as part of a robbery, and they say, we're going to rob this store together, okay? And B pulls out a gun and shoots the store clerk, injuring but not killing the store clerk, okay? I can tell you that they are both going to be charged, depending on some liability issues that will be sorted out when we get to party liability. Assume for the minute that A and B are both going to be charged the same way with that robbery and even with the harm that was caused to this person. But as you can imagine, the person who pulled the gun is going to be punished more heavily. So when you have parties who are doing things together, the basic principle of the criminal law is they should all be punished for the same act because they did it together. But when it comes to sentencing, that's when we sort out how seriously they should be punished, because that does differ. Now, while every sentence must be within the fundamental principle of proportionality, the court is allowed to consider different principles in enacting those ideas, which makes things very confusing because these are not always, they don't always go together. On one hand, you denounce. On another hand, you rehabilitate, right? A judge has to sort of balance between these various principles and use them where appropriate. Separation from society, one that is reserved for situations in which a person is dangerous to other people and needs to be incapacitated. Reparation, promoting a sense of responsibility. These are very important principles. What I'm going to say about them is judges can pull from them to advance particular objectives with regard to a particular offender. I can't be much more specific than that because frankly, as you'll see, I'm going to get to, sentencing really is an art and not a science, and it's up to individual judges to apply their common sense and wisdom in deciding what sentence to afford a particular offender within certain controls. That's why 718.1 is so important. So on one hand, the judges have freedom to choose from these principles in most cases, but on the other hand, ultimately, an appellate court will look at how proportionate the sentence is in regard to the gravity of the offense and the degree of responsibility of the offender. I should add that on occasion, the criminal code takes away the ability to use certain of these principles. So 718.01, when a child is abused, you cannot say, well, we're going to rehabilitate the offender. No, no, no. These are the objectives that dominate, and the courts must respect Parliament's will with respect to these types of offending. If that wasn't enough, there are some additional principles, and essentially these are what are called aggravating features. I can also tell you that there are mitigating features not listed in the code, but they are essentially developed at common law. These are essentially the types of crimes that Parliament is particularly concerned about. Hate crimes, domestic violence, offending against young persons, abuse of trust or authority, significant impact because of age or circumstances, again, robbing old people, and when you do something on behalf of a criminal organization or terrorism. These are things that tend to ratchet up the severity of your punishment. Now, I don't know what that tells you. It tells you there's a lot of principles controlling. Things are generally individualized. And there's still a fair bit of discretion. Many of those measures that I just put in are an attempt to control what judges will do, but there's still a fair bit of discretion. It's very difficult to get that out of the system, mainly because there are so many different factual scenarios that can come up when you're sentencing. Well, let's just say that some courts, especially the Court of Appeal of Alberta, have tried to put in a little bit more consistency and get rid of this individualized approach to sentencing by doing something that is now referred to as starting points. And the Court of Appeal looks at this as a statement of what typical cases are. You know, we have typical assaults, we have typical sexual assaults, we have typical murders, believe it or not, and what penalty these should receive. And the idea is that we look at all the court cases, the collective court experience, and a consensus view, and come up with a starting point. And essentially we would say, well, a robbery with a gun of a convenience store, we have a lot of those, that would normally start with a 4-year penalty, probably a 5-year penalty. Okay? And then the judge can deviate based on the relevant aggravating circumstances. Well, this was a hate crime. They robbed the place and sprayed a swastika. Make it 7 years. Or mitigating circumstances. Well, they didn't hurt anybody and the gun wasn't loaded, so nobody was really at risk. So let's make it 3.5 years. And by the way, I'm not sure you can do that because I think there are some mandatory minimums for handguns, but you get the general idea. That is the way starting points are supposed to work. So let's finish up with some important other things that you need to remember, what I've tried to get across with sentencing. It is an art, not a science. It really is where advocates do some incredible work, if they can, on the Crown side, trying to explain why a particular offending, the offender is dangerous, if he is or she is, and or has caused incredible harm, if they have. And the defense will come forward and put forward all the reasons why an offender needs to be sentenced in a delicate way. And ultimately, it really is an art, not a science. There is no mathematical formula that gets you through to point X of what the sentence should be. Despite all the constraints that I've showed you, trial judges still have a lot of discretion to choose. They still have a lot of ability to weigh all the differing facts in a case and make a decision. And the Supreme Court has really worked hard to try to allow that to happen. And the reason for that is because if you think of how many sentences are imposed every day, the truth of the matter is, if people were allowed to freely appeal their sentences, and appellate courts could interfere on a free basis, well, we thought this sentence wasn't harsh enough, well, we thought the sentence was too harsh, it just encourages too many appeals and it allows for too much randomness and inconsistency to come into the process. The Supreme Court has decided that sentencing is best done by the judge in the community, and unless this is way out of whack with what another offender would get in similar circumstances, these sentences should be upheld. Let's just say that between you and I would think that appellate courts wax and wane with their adherence to this principle. Every once in a while, an appellate court gets hit with a case that they just say, my God, there's no way this guy should get something this low. And they just do something about it. So generally speaking, this is the principle, and these principles are often expressed. The extent to which they're adhered to varies, I think, somewhat by each court. There is no rule that sentences have to be the same across the country, and the truth is they're not. Within individual communities, if you remember, one of the things is gravity of the offense. Well, for example, in offenses that are rife with drug offenses, drug trafficking, or communities that are rife with various types of violence, judges will impose harsher penalties, and there's nothing wrong with that. I have been to court proceedings in different parts of the country, and I'm always amazed at how differently judges punish in different parts of the country, because they have range and the ability to do that, and there's no rule that says sentencing has to be the same across the country. And frankly, because it's so important to our substantive criminal law discussion that's coming, I can't stress enough how much there is variance in terms of moral blameworthiness and personal circumstances. As you can imagine, one of the most important personal circumstances is, well, do you already have a criminal record? The first-time offender will generally get a discount because this is their first time before the system. People who are continually going back are likely to be treated more harshly because they are showing a difficulty with rehabilitation, etc. The variance by moral blameworthiness is also important. Again, your intention, your motivation, and your degree of responsibility means how much did you do? Were you a minor player, a major player, the mastermind? These are the way the courts look at how something that looks the same, a robbery, can result in very different penalties depending upon your personal record, your prospects for rehabilitation, and how much you did, and of course how much harm you caused in that robbery. A robbery where you terrified 10 people at gunpoint for 20 minutes is different than a robbery where you grabbed something and then pulled a gun only as you were leaving the place you were in. Right? These are different types of robberies, and they will be treated differently. And finally, I'd be remiss if I did not mention 718.2e of the Criminal Code, which says that when we are dealing with Aboriginal offenders in particular, although they do say this is for all offenders, but particularly for Aboriginal offenders, we should try to do things other than imprison. Frankly, I think that's the right approach for everybody, but the court has recognized the special responsibility that we have to Aboriginal offenders in this country. They are far too overrepresented in our prisons in terms of their percentage of the population, and too frequently the choice of imprisonment has been the first choice when it should be the last choice for Aboriginal offenders. And in a very important case called Gladue, the Supreme Court said that this section was designed to reduce the tragic overrepresentation of Aboriginal people in prisons, and it needs to be considered very carefully when we're dealing with Aboriginal offenders, because Aboriginal offenders are different. In sentencing Aboriginal offenders, judges should consider the unique systemic or background factors which may have played a part in bringing this offender before the courts, and, more importantly, the types of sentencing procedures which may be appropriate because of the person's Aboriginal heritage. And the courts have shown a willingness to look at other types of sentencing procedures where Aboriginal offenders are concerned, in particular because of this section, although it was done even before this section was enacted. We must take every effort to try and reduce what is happening with Aboriginal persons in prisons. So it's very, very important, although you can continue, obviously, to punish Aboriginal offenders where there is no other choice to do so. It is important to certainly look at other alternatives and use restraint whenever we are dealing with an Aboriginal offender. In any event, I hope that was useful to you as a way of looking at general principles of sentencing, and it should inform many discussions we have. Sentencing doesn't operate in a vacuum. It's very important to the substantive principles of criminal law as well. So I hope it's of use to you in those discussions. Have a great day.